Gun enthusiasts hope lawmakers will pull the trigger and lift the ban on silencers.
On our vehicles is because they're incredibly loud. That output is incredibly loud. The muffler helps dampen that noise. The suppressor is the same way.
How much louder is it without the silencer?
It's about 6 times louder without the silencer.
Fitted with a suppressor to kill 12 Americans in Virginia Beach.
Makers of the silencers are the ones pushing state lawmakers to lift the ban, and they have found at least one supporter.
Well, the Arizona Senate has passed a bill to make it easier to own a gun silencer, more accurately called a suppressor.
Legal battle. The case we'll be breaking down and discussing is called Paxson Vettel Bosch. This is an important and interesting case that was decided by a district court back in July on cross motions for summary judgment. The judge there believed that the plaintiffs lacked standing to bring this lawsuit, so the case was thrown out. The court also found that the statute of limitations should be followed. The Texas Suppressor Freedom lawsuit aims to eliminate the NFA and the ATF's regulation of maiden Texas suppressors. The ATF is currently attempting to have this case thrown out of the Fifth Circuit. Suppressors in Texas then appealed that ruling up to the Fifth Circuit Court of Appeals, and right now, the ATF is trying to argue that NFA taxes and those requirements essentially bar this case from proceeding forward in the Fifth Circuit. Ultimately, they argue that the Fifth Circuit should agree with the lower court's decision to dismiss this case. They even argued that the Fifth Circuit should not even hear oral arguments in this case.
Gun enthusiasts hope lawmakers will pull the trigger and lift the ban on silencers.
The State House still has to vote on the bill. 9 on your side's Craig Smith looked into how much difference a suppressor makes.
We were reminded how dangerous silencers can be a few weeks ago.
State lawmakers are considering several changes to gun laws, including making these much easier to get.
How much louder is it without the silencer?
It's about 6 times louder without the silencer.
Now all of this is coming to a head, and the Fifth Circuit has rejected the arguments that they should not hear oral arguments. They are, in fact, going to have a hearing in this case, and it's scheduled to take place the week of April 29th. This is a significant case with broad-reaching implications that we need to discuss. For those not aware, this lawsuit arises out of Texas House Bill 957 or HB 957, which aims to exempt from federal regulation all suppressors that are made in and remain within the state of Texas. The claim behind this specific law is that since these items are made and sold exclusively within the state of Texas, they do not fall under interstate commerce and therefore fall outside the purview and federal regulations of the ATF. After Texas passed this law, the ATF then sent out letters threatening that they will, in fact, enforce the NFA and GCA's regulations against maiden Texas suppressors. So despite what Texas had stated in their law, the ATF is still going to enforce this. In response, Texas, along with some individual plaintiffs, filed lawsuit against the government. This case was then submitted to a federal district court on cross motions for summary judgment. Second Amendment Challenge. Following a review of the case, the district court judge granted the government's move for summary judgment, resulting in the ATF won at the lower court level. The court ruled in favor of the government under the rationale that the plaintiffs, here the individual plaintiffs along with the state of Texas, lack standing to bring this lawsuit. Standing has 3 basic requirements that must be met for a case to proceed forward. First, there must be a concrete injury in fact that is not just simply hypothetical. Second, there must be causation or something that is fairly traceable, a connection between a plaintiff's injury and the defendant who is being sued. Third and finally, there must be some sort of redressability, essentially that relief granted by the court can actually cure that injury. On review, the judge here found that the plaintiffs have not suffered an injury, in fact, and therefore they have no standing. The judge essentially stated that the individual plaintiffs would have to allege that they either possess an illegal silencer or that they have engaged in some other prohibited conduct that the ATF claims is illegal. He also then said that they may be able to cure their whole standing issue if they, in fact, went through the NFA process. If they filed the forms to make a homemade suppressor, if they went through the process, well then maybe they could actually have standing. And that wouldn't matter whether or not they were approved or denied that maiden tech suppressor.
Well, the Arizona Senate has passed a bill to make it easier to own a gun silencer, more accurately called a suppressor.
As suppressors, illegal nationwide, just as they are in New Jersey.
For that reason, these things aren't oftentimes falling into the wrong hands.
We can't pick and choose, and we have to follow the laws, but people don't understand.
Mufflers on our vehicles is because they're incredibly loud. That output is incredibly loud. The muffler helps dampen that noise. The suppressor is the same way.
Just going through the process maybe could cure the standing issue. So in essence, the judge required the individuals to subject themselves to the unconstitutional process that they're actually challenging. Finally, the lower court found that Texas itself as a state also did not have standing to sue on behalf of their residents. Now in response to that, Texas then did file an appeal to the Fifth Circuit, asking for the Fifth Circuit to review that granting of the summary judgment and essentially find that the lower court was incorrect. Recently, the ATF responded to this appeal and argued that under the Tax Anti-Injunction Act or the AIA, this lawsuit was improper from the start, and essentially it would result in the avoidance of individuals paying a required tax under the NFA. So they're using taxes as a basis to claim that this lawsuit is invalid. The ATF claims that under the AIA, there is a specific process that you have to go through to bring lawsuit like this. Essentially, they're saying this lawsuit was not through the proper channels under the AIA. The individuals here would have to go through the process. If they didn't like having to register or pay the tax, well then, they would take that up with the Attorney General. They would file a complaint for a refund from the Attorney General. If the Attorney General then decided not to grant a refund, well then they could sue for the refund. But they're saying this generalized request in the lawsuit against the ATF based on the maiden tech suppressor issue is not the proper channels. They have to go through the AIA, and this whole avoidance of an NFA tax bars this lawsuit. Then the ATF argues that the Second Amendment is not implicated at all when it comes to suppressors. And this is where the whole Second Amendment challenge comes in. They state that the Second Amendment's protection extends only to instruments that constitute bearable arms and that are typically possessed by law-abiding citizens for lawful purposes. Because the Second Amendment covers only bearable arms, laws that regulate arms accessories or attachment do not necessarily implicate its protections. And a silencer is an arm accessory, it's not a weapon itself. So this is the position that the ATF is taking. It's not a weapon itself, it's simply an accessory. And they claim that accessories like suppressors are not protected by the Second Amendment, not acknowledging the fact that these ATF and federal regulations themselves and the NFA-GCA actually treat suppressors themselves as true arms. They are regulated as actual arms within their own right, but the ATF wants the court here and everyone else to forget that. Now in response, Texas goes on to point out in their brief and tear down everything that the ATF said. They argue in their brief that the whole tax issue and the NFA tax requirement is not even at issue at the Fifth Circuit level. Really, what's at issue here is whether or not the state of Texas and the individual plaintiffs had standing to bring this lawsuit. ATF in Paxson Vettel Bosch case. Texas contends that this matter is not before the court. The parties briefed the matter in great detail below. The appellants noted that only one of their 4 claims involved the Anti-Injunction Act and that the exceptions applied even to that claim. Nevertheless, the district court did not rule on the Tax Anti-Injunction Act, nor was it required to, preferring to rule solely on standing and the injury in fact prolonged. This means the court should not take the parties' Anti-Injunction Act arguments into consideration. The district court should consider them on remand. So again, they're pointing out the fact that this whole dispute, this whole appeal is about whether or not the plaintiffs have standing, whether or not Texas has standing, and whether or not they have suffered an injury in fact, which is required for standing.
Fitted with a suppressor to kill 12 Americans in Virginia Beach.
Makers of the silencers are the ones pushing state lawmakers to lift the ban, and they have found at least one supporter.
Some people call these a silencer, but how much silence are we really talking about?
That, as the sheriff, we're the keeper of the jails. We do have a say who can come in and out of our jails.
We don't want to have those silencers end up in the wrong people's hands. One way to definitely do that is not sell them here in Illinois.
That is what is being disputed. But the ATF wants to throw in all these other side issues to kind of sidestep what is really going on. When it comes to these Second Amendment arguments, Texas points out in their brief that because of the Supreme Court's 6-3 decision in Bruin, which struck down New York's canal Gary processing scheme, Texas and the plaintiffs do have standing to challenge the interface process itself. They argue that post-Bruin, whether citizens may challenge requirements to apply for permission to exercise Second Amendment rights is an open question. Although ATF cites these opinions as controlling authority from this court, it saves this argument for last, surely because it recognizes the shaky status of these opinions post-Bruin. Here, the state of Texas is directly referencing the Supreme Court's Bruin decision to highlight the post-Bruin ideology that states like Texas and plaintiffs involved in this case have the ability to challenge application processes that serve as a barrier to the exercise of our right to keep and bear arms under the Second Amendment. This is precisely what is being challenged in this lawsuit. And as a result, the lower court's dismissal of the case for lack of standing also directly violates the Supreme Court's ruling in Bruin. It is currently scheduled that oral arguments will occur during the week of April 29. Since the ATF is taking an outrageous stance on the NFA tax, and they've kind of brought that up in the context of the pistol brace lawsuit. That's all for this video, folks. See you next time.